Today's topic on which I am going to talk is rule of law. All of us want to usher in rule of law society, where we want to touch, test everything on the touchstone of justness, fairness, and reasonableness. We have to trace the history. Turning back the pages of history, we find different notions, different approaches relating to rule of law. I can refer to the thin notion and thick notion. Thin notion we talk about when we refer to procedural restraints on all the organs of the state. Initially, when we did not segregate into different organs of the state, of course, we used to talk about when norms are there, any kind of rules are there, that there must be some kind of procedural restraint. Thick notion, which is very, very wide, where we differentiate between what is right, what is wrong, what is good, what is bad. Now, historically, if we go to the ages when the emperors used to be there, they had their own notions, own perceptions of rule of law. Like in the colonial period, if we talk about rule of law, maybe that racial approach, discrimination on the basis of color. Now, in the present times, as we are proceeding further, we have the living abodes, the constitutions of different nations. But even different nations' constitutions, they are struggling on the component of sovereignty because number of factors have intervened. Like I can talk about economic constitutionalism. Nowadays, we don't confine our rights merely to what was there when we had universal declaration of human rights or our constitution was framed. We want to talk about whether intellectual property right is a fundamental right, whether right to development is a fundamental right, whether consumer right is a fundamental right, and so on and so on. Again, tracing back, I can refer to Aristotle. Aristotle in 350 BC, when talked about would we like to be governed by best men or best laws? And he himself answered, it depends upon what kind of regime is there and what kind of laws are framed by that regime. Going further, if I refer to John Locke, his book on True Treatises of Government in 1689, when he talked about that governance should be through established laws which are known to the people. Passing on to Montesquieu, don't think separation of powers or theory of checks and balances in the modern time is something which can be divorced from rule of law. Now, if we confine all the powers in one body, there will be chaos. There will be no fairness. And of course, this concept of separation of powers is a sister concern of rule of law. At this juncture, I am forced to think, and I want you also to think, whatever happened historically, should we follow the contaminated rule of law? Or in the modern times, especially in COVID-19 pandemic situation, I can talk about that. Should we have pre-vaccinated rule of law? Should we have the treatment for if there is violation of rule of law? Now, I would like to talk about the French term la principe de legalite, the principle of legality. And we say, Edward Coke long back said that law and God should be above the king. And we used to say, kingship knows no kinship. Then I'll come to Dicey because we think Dicey gave this concept of rule of law. But before that, I would just like to refer to Fuller, his principles of inner morality of law. He gave 8 principles like law should be general, public, prospective, coherent, clear, simple, congruent, intelligible, practicable. All these principles have to be there, and we understand very carefully that if these principles are there, of course there will be presence of rule of law. 1977, Raz, he talked about procedural aspect of rule of law. But in the modern era, we can't confine to the procedural aspect. We do talk about substantive aspect of rule of law. Before I talk about ISA, I would like to give you the example of the substantive aspect. Like we have one very, very important fundamental right, that is Article 21, which guarantees right to life or personal liberty. It simply says, no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, when the Constitution was being framed, a lot of discussion took place whether to adopt American due process clause or not. We did not. There were a number of fears in the minds of the framers of the Constitution. But ultimately, after Maneka Gandhi's decision in 1978, we imported procedural due process, and after Mittu versus State of Punjab of 1983, we imported even substantive due process. Now, this is due process is nothing but fairness, justness, reasonableness. Now, coming to Dicey. Dicey gave this concept in 1885, and he gave three meanings to this concept of rule of law. Number one, absence of wide discretionary authority in the hands of government officials. Justice should be done according to the known principles of law. Second was just similar to Article 14, equality before law and equal subjection of all to the ordinary law of the land administered by ordinary courts of the land. We are not concerned with the third principle because in India we have a written constitution. In England, there's no written constitution. That is why Dicey talked about the fundamental rights are not the result of the constitution. They emerge because of the disputes settled by the courts on the basis of the customs and traditions. Now, Dicey's concept does not have that relevance today as we are proceeding forward in our journey. But still, we appreciate. At that time, it was a fashion to criticize Dicey, and Ivor Jennings did it the most. Like at that time, also, Parliament was supreme in England, and Parliament could frame any law except making a man a woman or woman a man. At that time, also, everybody was not subjected to ordinary law of the land. It's not that there was no privilege granted to anybody. At that time also, there was a concept, king can do no wrong. And this continued till the passage of Crown Proceedings Act 1947. At that time also, because there was separate military law and ordinary law. So number of such examples we can take to criticize Dicey. But one concept we carry, that is, we have to distinguish between arbitrary power, discretionary power, and wide discretionary power. Arbitrary power is when the guidelines are not given. What is the power which is vested in you? How you have to exercise the power? Is there any control mechanism? If these are lacking, we call it as arbitrary power. But once the guidelines are there, limits on the exercise of power are prescribed, and it is subject to a appropriate valid control mechanism, we call it as discretionary power. There is just a hairline difference between discretionary power and wide discretionary power. Everything else is present. The moment control mechanism becomes weak, discretionary power is converted into wide discretionary power. Even Wade talked about this rule of law, that rule of law means absence of arbitrary power, supremacy of parliament, and independence of judiciary. It is very, very important to talk about Do we recognize the concept of rule of law under the Indian Constitution? Answer is yes, but apparently some provisions may appear as if objecting to, as if opposing the rule of law. I can refer to Part 3rd of the Constitution. Part 3rd, all the fundamental rights, these are in favor of rule of law. Whether we talk about right to equality, I must tell you, initially, right to equality was taken as merely a principle of no discrimination, and the test was there for reasonable classification. With the passage of time, especially when E.P. Royappa's case was there in 1974, the Supreme Court said right to equality is antithetic to arbitrariness. And now, after this decision, passing from Maneka Gandhi and many other decisions, whenever we have to challenge any law, any executive action on the ground of that there is misuse of power, there's arbitrary exercise of power, then we can challenge it on the ground of Article 14 only. Passing on from this small island, Article 15, 16, 15, 16, which are specific rights to equality, 17, untouchability, 18, no conferment of any titles except military distinctions and academic titles. When I come to the freedoms, now, without the freedom, without ensuring rights, we cannot usher in a rule of law nation. But no right is absolute, no freedom is absolute. So reasonable restrictions can be imposed. Article 20, where we talk about rights of the accused person, like protection from ex post facto laws, protection from double jeopardy, protection from self incrimination. And then, if I talk about Article 22, when we talk about the safeguards when any person is to be arrested or to be detained under preventive detention laws. 23, 24 talk about right against exploitation. Now, so on and so on. As I mentioned, Article 21 also, right to life. And today, just because of widening of the scope of Article 21, because of the living abode of concept of rule of law, you name any right and that is part and parcel of Article 21. Even if I refer to directive principles of state policy which impose duty on the state, now we get vibes of rule of law. Even though you must be thinking that the directive principles are not enforceable in a court of law, but we have the example that so many directive principles have been converted into fundamental rights by virtue of judicial interpretations. There are certain principles which we feel are not in favor of rule of law. Like if I talk about Article 74. Article 74 says there shall be a council of ministers with the prime minister at its head to aid and advise the president, who shall be bound by the advice. And the proviso says once he can send back the advice for reconsideration. We have clear decisions. If I refer to Care Singh versus Union of India of 1989, that what advice was given to the president cannot be questioned. So we feel that this is not in favor of rule of law. But I'm reminded of first judge's transfer case, SP Gupta versus Union of India, that the court can ask for the material on the basis of which advice was given. So we put this on a balance, whether this is in favor or this is against rule of law. Then we have Articles 105 and 194, where we talk about the privileges of the parliament and state legislative assemblies. Similarly, Article 361, where we talk about the privileges of the president and the governor. And if I refer to emergency provisions, whether starting from 352, we may talk about national emergency, state emergency, or financial emergency, we feel this is something against the rule of law, even though We have the darkest period in the judicial history if I refer to ADM Jabalpur versus S. Shukla of 1976, where they talked about taking Article 21 as a sole repository of right to life or personal liberty, taking it as only rule of law. While we have wider concepts, even if Article 21 is not there, now there's universal application of rule of law for no arbitrary exercise of power, whether it is legislature, it is executive, or it is judiciary. And just we when we further pass on to, I can refer to even 25th Amendment Act, where supremacy was given to Article 39B and C over fundamental rights. Now we must realize what is 39B and C. Equitable distribution of income, equitable distribution of material resources. Now what we want? Do we want positive equality or negative equality? If we want positive equality, of course, we have to make Article 39, Clause B and C as living reality. And I think this is what should be the desire of every citizen of India. Now, we may refer to Articles 121 and 122, like 122, the procedural irregularities in the parliament cannot be questioned in a court, or 121, the conduct of a judge as a judge cannot be discussed, cannot be questioned in a court of law, except when the judge is to be removed. So, we have different notions, but we can justify and finally reach the conclusion that yes, our constitution is sovereign. Our constitution is sanctum sanctorum. If it is sanctum sanctorum, it is, and it is taken as a grand norm, that is because of the presence of rule of law. Now, in the modern times, it's not that we confine to any regional concept of rule of law or merely a national concept of rule of law. We have to talk about the global rule of law. Global rule of law, we can refer to World Justice Project Rule of Law Index report. Now, initially there were 9 factors, now there are 8 factors. Very, very important. In fact, I have almost indirectly touched. First is constraint on government powers. Now, constraint. Legislature puts constraint on the government powers. Once exercised, this can be tested under judicial review by the courts. Similarly, the legislative power also can be tested on the same touchstone as I talked about, the due process through judicial review by the courts. And second factor is absence of corruption. Absence of corruption. When there will be absence of corruption? When there will be rule of law administration. And rule of law administration when there's no question of arbitrary exercise of power. Now, if we exercise power by corrupt means, then we can't say that the officer used his discretionary power, because for discretionary power the officer is bound to follow certain norms, the guidelines, whether power has been vested in me, whether I am exercising power as per the limits prescribed. And I must understand that I'm amenable to some kind of control mechanism. Now, we have, in fact, role of the Supreme Court also here, that number of concepts have been developed, like Wednesbury principle, which was innovated by the English courts in Associated Provincial Picture House Limited versus Wednesbury Corporation in 1947. We adopted it in Delhi Science Forum versus Union of India in 1996. It literally means fairness, that there must be plausible justification for taking any action, taking any decision. And then we have the doctrine of proportionality, which was there already, but further developed by the Supreme Court in 2001 in Om Kumar versus Union of India. And at the same time, I must tell that we have the power, but we prefer to misuse or abuse the power. Gone are the days when we could wash out our hands. But now, the Supreme Court, in fact, developed another very, very important concept of public accountability or personal liability. I can just refer one uh, observation by the Supreme Court in GN Khajuria versus DDA in 1995 that if anybody prefers to misuse power, beautifully, Supreme Court said, if you make hay while the sun shines, you must face the consequences. And now, if we misuse the power, then of course the victim can be compensated and the compensation can be recovered from the pockets of the accused. Now, this is again when we talk about restraint. Then another factor here is open government. Open government or good governance, they are almost similar. Now we know for that purpose transparency is required, complete information is to be given, participation is required, and that is not possible without rule of law society. Fundamental rights. We are very, very fortunate. Another factor, these fundamental rights are enshrined under part third of the Constitution. Then the next factor talks about order and security. Then we talk about regulatory enforcement, then civil justice, criminal justice. Now, if I look at the role played by the Supreme Court, Supreme Court is making efforts that we survive in rule of law environment. If I talk about just one example of Swapnil Tripathi versus Union of India of 2018, live streaming of the proceedings of the Supreme Court. If I talk about Union of India versus High Court of Rajasthan of 2017, I can talk about that nobody can be discriminated on the basis of his or her status. Here, the question was no frisking of High Court judges on the airports. Now, this is not accepted by the Supreme Court. I think we understand that this is in consonance with the rule of law. When we talk about our right to reputation, when we talk about our right to reputation, as was heard in Subramaniam Swami's case of 2016, or right to privacy, as it was finally determined in case Putta Swami case in 2017, and a number of issues as we proceed further, like if I talk about Shaira Banu's case, that how triple talaq was declared as unconstitutional. One of the meanings given by Daisy regarding rule of law was equality. And similarly, I can refer to National Legal Services Authority of India versus Union of India, where the rights of transgenders were recognized and guidelines were issued by the Supreme Court. Even we can talk about Navtej Singh Johar, again talking about the rights of LGBTQ. Now, we are just proceeding towards a better society where we can talk about the presence of rule of law, distinguishing between rule of law, what we are talking today, a rule according to law, rule by law, which used to be there. Rule by law simply means law which is enacted law, may or may not be fair, just, and reasonable. We have so many examples because the all the factors we are trying to make all these factors as living reality, like we have those cases of Tahseen Poonawalla versus Union of India, or Tushar Gandhi versus Union of India 2018, where we talked against mob lynching. Even I can refer to the Sabrimala review petition, where the Supreme Court just observed that if we have to keep our trust with destiny, then we have to be wedded with rule of law. And even Justice Dipak Gupta In the case of Krishan Prasad Verma versus State of Bihar in 2019, said Supreme Court has to perform its role. Supreme Court has to be in judiciary has to be independent, whether it is highest judiciary, higher judiciary, or subordinate judiciary, if we want the presence of rule of law. Even Justice Chandrachud in the case of FCI versus Jagdish Balram Bahira talked about that Supreme Court, when follows the constitutional principles, follows rule of law. And I understand that all the three organs have to perform very, very important role if we want to live in rule of law society. I would just conclude, I can share with all the viewers that I'm a poet by heart, and I can just explain to you what is the rule of law in a poetic version. कानून कहीं अपराधी ना हो जाए, कानून कहीं अपराधी ना हो जाए, न्याय बनाया सर्वशक्तिमान ने। नियम केवल कानून के नहीं, कानून के लिए भी नियम है बनाने। नियम केवल कानून के नहीं, कानून के लिए भी नियम है बनाने। कानून का पालन हम करें, कानून का पालन हम करें और कानून कराए नियमों से पालन, तभी सर्वमान्य होगी न्याय प्रणाली और उसका शासन। अवलोकन और आलोचना संतानें हैं किसी भी व्यवस्था की। अवलोकन और आलोचना संतानें हैं किसी भी व्यवस्था की, इनकी अवहेलना और उल्लंघना है गाथा व्यवस्था की व्यथा की। न फेंको पत्थर न्याय के मंदिर पर, न फेंको पत्थर न्याय के मंदिर पर, बिन सोचे बिन जाने ही। नहीं करो प्रदूषित इसकी वेदी, चाहे भ्रष्ट हो इसके कण अनजाने ही। अगर रक्षक हैं न्यायाधीश, अगर रक्षक हैं न्यायाधीश न्याय मंदिर के, तो वकील हैं इसके सेनानी। अगर रक्षक है न्यायाधीश न्याय मंदिर के, तो वकील हैं इसके सेनानी। सामंजस्य, सहजता और सरलता हो, मगर निष्पक्षता न हो बेमानी। सुसंस्कृत और नियंत्रित हो, सुसंस्कृत और नियंत्रित हो जिरह और शब्दों के चित्र। चाहे हो अदालत के बंद द्वार, या घेरे हैं तुम्हें तुम्हारे मित्र। न्यायमूर्तियों का दर्जा शायद आता है रब के बाद, न्यायमूर्तियों का दर्जा शायद आता है रब के बाद, परंतु मानव है, रब नहीं। कोई नहीं है कमजोरियों से आजाद। फाइनली आई प्रे टू गॉड, ए रब, ए ईश्वर, ए रब, ए ईश्वर, निंदा और स्तुति से दूर रहे ये न्याय की देवी तो अच्छा है। ए रब, ए ईश्वर, निंदा और स्तुति से दूर रहे ये न्याय की देवी तो अच्छा है। शब्दों की तलवार जिह्वा की म्यान से न निकले तो अच्छा है। थैंक यू। सर्वे भवन्तु सुखिना। Now I would welcome the questions from the viewers. Uh, there's a question regarding on Balco's selling matter where the Apis court refused the challenge against such low price selling by the government. I must tell the person who has asked this question that we have one principle of separation of powers, which we call as theory of checks and balances in the present times, and the functions have been assigned to three organs of the state. No doubt these functions cannot be fixed in the watertight compartment, but at least assignment is there, and there are certain essential functions belonging to every organ. When we talk about the executive power or governmental power, the policy decision, this is the essential function belonging to the executive. And in the essential function, even the Supreme Court cannot interfere. Now, this has to be justified on certain grounds. That ground may be question of reasonable classification. Like I can give you one example of a decision in 1993. There was a case of Hindustan Development Corporation. Now, here what happened that the railway department decided to purchase some railway bogies and tenders were invited. The big manufacturers they gave the tender with the lowest price, knowing well that they are going to suffer losses, but they wanted the contract under all circumstances. And while the small manufacturers they quoted the price which included their expenditure as well as their profit. Now, here, if we go by the practice, if we go by the principle of legitimate expectation or even equality principle, then the tender should have been gone to the big manufacturers. But the government, the railway department decided differently. And here they decided to give contract to both, to the big manufacturers, to the small manufacturers on the prices quoted by them, they being economic protector of the country. And this is the reply to your question. I hope you're satisfied. Now, next question is mainly focused on the judge made law or the precedents. Yes, traditionally or literally, we do talk about that lawmaking function belongs to the legislature only. But when the legislature sleeps in slumber, or when certain provisions are vague, or we need new interpretations with the need of time, what should be our expectation from the highest judiciary? My question, and replying to your question, if I remind you of, had the Supreme Court not innovated the theory of basic structure in Keshwananda Bharati, what would have been the situation? Because if we read the minority judgment in Keshwananda Bharati, the approach was that constitution can be destroyed or changed in one stroke. Would you like it? I think answer is no. There are many examples, like if I talk about DK Basu, this is nothing but judicial legislation incorporated after long, long time in criminal procedure code. If I talk about Vishaka versus state of Rajasthan of 1997, no, there was no law relating to protecting women from sex harassment at workplace. No law passed by the legislature. 1997, the judgment came. When was the law passed? 2013. Enforced from 9th December 2013. Now, should we keep on suffering? But I must say, that no organ of the state has to cross its boundaries. That is why, wherever such directions or guidelines are there, the judgment in the operative part, we find in the judgment that this shall be effective till the law is passed by the legislature. And number of examples can be there, like what happened in Shaira Bano. Should we keep on suffering and wait for some legislation? Or should there be wide interpretation? Had there not been wide interpretations by the Supreme Court, like you can take the example of even right to education through Mohini Jain and Unni Krishnan. Now, this became a fundamental right expressly by 86th Amendment Act 2002 only, and those case, the Unni Krishnan case was in 1993. I think you have got the reply. Very good question. What is the role of PIL in the establishment of rule of law? Public interest litigation. I think we started with this late 70s, early 80s. We know ignorance of law is no excuse, but we prefer ignoring our rights. I am a poor worker, a daily wager. I every day wait for somebody will employ me and I'll get some money and I'll have two square meals a day. Can I think of my fundamental rights? That yes, I am being exploited. I'm not being paid minimum wages, or I don't have a shelter, I don't have a food to eat, I don't have a clean drinking water to drink. No. Under these circumstances, any awakened citizen prefers to question it. Where lies the harm? And this was the reason behind having PIL. No wayfarer, no interloper, only in the public interest. Now, in the public interest, if the question of fairness is questioned before the courts, where lies the harm? I can give you the example when we thought of having this PIL. I can refer to Ratlam municipality case. Now, what happened? What kind of demand was there? Now, can there be a rule of law society if I can't live in dignity with open drainage, with all kinds of smells, and and invitation to all kinds of diseases? Just imagine, this request was not accepted by the municipality. Matter reached up to the Supreme Court. Judgment was delivered by Justice Krishna Iyer. I'm a great fan of Justice Krishna Iyer. And you know what Justice Krishna Iyer said in that decision? That had the municipality preferred spending whatever they have spent for fighting as cantankerous litigant, and of course with some social service by the residents, the matter would not have reached here. So this PIL, of course, helps. And if we have this rule of law, the living abode of rule of law in the constitution, this is because of so many BILs which have been filed. I hope you are satisfied. Now, this is again a very important question, that if any foreign company, now immediately I'm reminded of Bhopal gas disaster. I know number of lacunae are there. I know still we can feel the screams of the people who suffered at that time. But efforts have been made. Here, I would like to tell you the very first question about the foundation stage. against whom the fundamental rights are guaranteed. Guaranteed against the state. State is defined under Article 12 of the Constitution. Article 12 talks about the what is included in state. State we say like union parliament, union executive, state legislature, state executive, local authorities, and other authorities. Now, we pass through a tough journey to reach the conclusion what is the meaning of other authority, right? And other authority now any instrumentality or agency of the government. Now, here the first problem will be regarding claiming our fundamental rights against the foreign companies, which may not be covered under the term state. Even they are not taken as a natural person. Again, we had passed through number of situation. Can they claim fundamental rights also? And finally, in Delhi cloth mills case, we did talk about that it is only lifting of the veil. Otherwise, we look at who are the shareholders, who are the directors, indirectly whose rights are being violated. uh, but keeping apart the fundamental rights part, I must say that in the present circumstances, there has to have rule of law irrespective of that who is violating this rule of law. Because nowadays we talk about the global global rule of law, and even the companies etc, because everything can be tested on the touchstone of the rule of law. Now the companies who are violating, they function without any rules, regulation, norms? And can we say those norms violate the basic principle of fairness, justness, or can any person exercise any power arbitrarily? Now, this is equally for all. Next question is a wonderful question, whether post poll alliance is constitutional. Is it not ruled by law? Yes, this is very, very important. So we have to distinguish. First problem is that we have multi-party system. Second is we face the issue of criminalization of politics. Third, I can talk about what you are referring to, post-poll alliance. If I open the pages of the Constitution, I don't find anything, any provision when I look at the composition of the parliament or the state legislature or the qualifications, etc., except the practice, or when we talk about anti defection laws. Two things where we can touch the issues. But anti defection law also does not come into picture because there is something before the formation of the government. But for formation of the government, there are certain principles which are followed. Like if election is complete, we may take like the situation at the center. We can take that example. The first option before the president is to invite the single largest party. If there is no single largest party, then next is leader of the opposition. Now, leader of the opposition claims I will form the government, but then he has to be tested on the floor. On the floor, he loses, cannot gain the confidence of the house. Then Next option is alliance before the election. Everything fails. And we are not that wealthy country that just after few days of election and we can afford another election, believing that we the people are sovereign, so we have to decide. So that is why a kind of practice is then leader of the alliance, which is after the election, is invited. In fact, many efforts have been made to control this. Now, you may call it as the rule of law, you may call it as rule by law, law, not exactly enacted law, law which is by practice, which has become customary, which we are following from England also. And if you want to call it as rule of law, then we say that we have to take a, the uh, best decision at that time. And I'm just reminded of once again Aristotle. Now, should we go by the best decision or should we go by that, yes, rigidly we have to fix this rule of law in a watertight compartment? Next question is whether the state governments are following rule of law while making appointments. Appointments, recruitment. Whose prerogative it is? It is the government's, the employer's prerogative. But if we say rule of law has to be followed, then this has to be as per the norms. Now, I can give you the example of when we talk about public employment. Immediately, I'm reminded of Article 60. As I said few minutes back, that we have a board of rule of law under this small island of right to equality. Article 16 guarantees equality of opportunity in matters of appointment and employment. And at the same talks about no discrimination on certain grounds. Religion, race, caste, sex, place of birth, descent, residence, no, all these grounds are there. Now here, whether appointments are to be made or not to be made, this is the policy decision to be taken. Now, once the decision is taken, then the safeguards so that every eligible person has equal opportunity of employment and appointment. Now, what is this equal opportunity? Equal opportunity does not mean that you are eligible, so you have a right to be appointed. Equal opportunity means that you, if you are eligible, you have a right to be considered. This consideration is your right. But then again, this is a policy decision that even when advertised, the employer decides not to fill up the post. You cannot question it. Sorry, I should say, you can question it only when you can prove that the decision is malafide. And I tell you, it's the most difficult thing on the earth to prove malafide because you can't read anybody's mind. You have only safeguards like the person who has been appointed is as per the merit, number of norms to be followed, eligibility, last date to consider eligibility is the last date of submission of application form. As per the merit, everything is transparent, the criteria are properly referred to. If the employer decides to shortlist, then there should be complete policy and procedure for shortlisting. I'll just reiterate, even if you are eligible, still you cannot claim to be appointed. Your only claim can be you should be considered. Now it's time to conclude. Thank you very much for joining and hearing me patiently. And as all of you know, who am I? And anytime any query is there, I'm always available. And thank you very much. God bless all of us.